Good morning, everybody. Thank you all for joining us today. I think we're almost all in from the waiting room. And all these little pop-ups for allowing things like transcripts. Let's see, we've got one more person coming in. All right, I'm going to go ahead and get us started. We'll have folks trickling in, I'm sure, for a few more minutes. I want to start by doing what I do every week, which is thanking you all for joining us. We're glad that you're here with us today. Our Zoom housekeeping tips are that we do ask you to stay muted during the Zoom unless you would like to unmute yourself to ask a question, which you're welcome to do. If you're curious about your Zoom toolbar, which I imagine most of you are old hats at this by now, but I did just put a message into the chat, so your toolbar might be flashing. That's where you're going to find the chat button. That's also where you're going to see your audio and video buttons, so you can turn your microphone on and off and or turn your video on and off. You're welcome to be on camera or off today, whatever is most comfortable for you. The chat is the best way to ask questions or ask us to clarify something that we've said today. And if Jennifer and I are really efficient, and by that I mean if I talk less than I usually do, we might actually have time to get to some questions from the chat. So feel free to put some questions in there if you guys have those for us. As I remind you every week that we're together, as we remind you every week that we're together, we are not here to give legal advice. We are here to discuss general legal stuff that is broadly applicable to community associations in Washington State. So when your questions are too specific, sometimes you'll get an email back from Chelsea telling you that we just can't cover the question at all. Other times we will reword the question to make it general enough for us to be able to discuss the topic without giving you legal advice. So if you find yourself sending us a question that is multiple paragraphs long or copying and pasting sections of your governing documents into the question, it's probably too specific and you're probably asking for legal advice. So keep that in mind and try to tailor your questions accordingly. I'm going to be popping a few other things into the chat, including what I'm going to put in there right now, which is a link to sign up for the Monday Morning Minute. This is the Monday Morning Minute is an email that is sent out, as you might imagine, every morning, a Monday morning. It's short. It's drafted by our Legislative Action Committee chair, Hillary Bublitz, who's amazing at her volunteer job in addition to her day job. And this is the way that we work really hard on the LAC to keep you guys informed about what's going on. You might, if you've already subscribed to that, have noticed that the last couple of weeks we've sent out calls to action where we are asking the constituency of WSCAI members to contact legislators about a particular bill. One of those, for example, is Senate Bill 5686. Had to think about that for a second. And I am going to put a link to the current version of that bill into the chat. And this bill is expands and funds the foreclosure mediation program that currently exists under the Deed of Trust Foreclosure Act. But the bill also specifically seeks to make associations subject to that mediation program. And we have worked really closely with the prime sponsor of the bill to try to balance the intended effect, which is to try to help homeowners to avoid foreclosure whenever possible, try to facilitate communication between homeowners and their board members to avoid foreclosure if it's possible, to try to balance that effect against what we see as the potential negative repercussions, which include things like slowing down the collections process and driving up costs for community associations. And we have not yet gotten to a place where we feel like we can support that bill. So there was a call to action that went out this week asking folks to contact their legislators to urge them to vote against that bill. So if you're curious about the contents of the bill, I did put a link to that in the chat. If you haven't signed up for the Monday Morning Minute yet, I really encourage you to do that. Also, there's a link for that in the chat. CTA news, the latest on that is that the Treasury Department has announced that it's seeking to revise a rule that will allow it to not enforce the CTA against US citizens and United States companies. So this, I want to caution everybody that this is not a revision to the actual statute. The statute remains as it was originally, or as it was recently adopted, and the reporting requirements are still in the statute. However, the Treasury Department would essentially be exercising its rulemaking authority and would be adopting a rule. That's what they're planning to do, saying we're not going to enforce this against United States citizens and United States companies. So you can take that for what you will. The statute does still remain in its form with the reporting requirements in it. It is possible that that rule might be enacted. It's possible that rule might go away, either under this administration or a future one. But that is the latest update. So the risk of non-compliance with the CTA's reporting requirements appears to be pretty minimal at this point, but that could change at any time. The last thing that I want to tell you about from an announcement point of view is that WSCAI's annual conference is coming up. It's April 24th to the 26th. I'm putting a link to the event for that in the chat. And if you haven't registered, we would love to see you guys there. Ken is speaking, Katie is speaking, I'm speaking. We're going to have a booth. You could meet Chelsea. Most of the attorneys that work for the firm are going to be there at one time or another. So if you haven't thought about attending, we would love to see you there. And the link to that event is in the chat. Jennifer, is there anything that I'm forgetting to cover before we jump into the questions?
I don't think so.
Okay. All right. Let's get to it. Our first question is this. The Washington State Nonprofit Corporations Act allows our board to delegate the powers of the board to committees of the board because elected directors have voting control of those committees. It's hard to know which authorizations a board has that would be considered a power of the board for this purpose. The board is authorized to do so many things, including things like facility maintenance, that would typically be delegable to others, such as contractors, employees, management companies, or even volunteers. How do we discern which is a power of the board that can only be delegated to a committee of the board? I think where you start is you look at the powers of the board as they are defined by the governing statutes. So those are the sections that talk about the powers of the board for the Condominium Act. And this provision is applicable to old act condos as well. It's RCW 6434304. For HOA Act communities, it's RCW 6438020. And for Wakaiowa communities, it's 6490405. So that's where you see the enumerated powers of the board as defined by the statute. And I think one distinction that I would make is the board is the sort of policy-making body for the association. Board members might also do actual nuts and bolts things like changing light bulbs or keeping the books if you're a self-managed community, right? But the authority of the board, as I conceptualize it when I hear that phrase, is really more about their rulemaking power, their decision-making power, their policy-making power. And that's the kind of distinction that makes sense to me when I'm thinking about how you would delegate authority to a committee versus when you hire a vendor to do a thing like landscaping or bookkeeping or whatever. I do think the board has broad discretion to delegate its authority, but it can't be used. I will say this is very important to avoid open meeting requirements. So that's one thing to keep in mind. But going back to my previous point, hiring a contractor to perform a service is not the same thing as delegating the board's power or authority. The decision to hire the contractor is a board power, the decision, the making of the decision, but the actual hiring of the contractor and then letting them do the thing you've hired them for is not a delegation of board authority or power. That's just somebody doing something you've hired them for. So you could delegate to the committee the decision of whether to hire a contractor. So for example, let's say that you are contemplating a large landscaping project in your community, and the board of directors wants to delegate to a landscaping committee the authority to interview, get bids, interview several companies, and make a decision as to which landscaping company to hire for the project. The delegation of that decision is what is contemplated when the statute talks about delegating board authority to a committee. The actual hiring of the landscaper to do the thing once the decision has been made is completely different. Some boards also delegate to their management company certain functions of the board that, you know, the things that would normally be under the board's authority. So things like issuing violation notices when there is a reported violation of the governing documents, sending delinquency notices once an account falls behind, things like that. Those are things where the board has the decision-making authority. Send a delinquency notice anytime somebody is 30 days past due or more. Send a warning notice anytime there is a reported notice of violation with evidence to support that the violation actually occurred. That's decision-making authority that the board can delegate to its manager. But the actual doing of the thing, sending the fine notice, sending the delinquency notice, that is a service that you've hired your management company to do. I think there are two other things that I would say about this. One is you just have to exercise some common sense in deciding what is delegated and what's not. Written descriptions of delegated authority are very helpful. I think documenting anytime you delegate authority to a committee or to an individual, you want to put that into the board meeting minutes for sure, so that you have documentation of the fact that the board as a whole made a decision. So one example of this might be that a board votes to let's say one of your board members lives on site and works from home, and the board decides that person is the one who should contact the towing company if somebody is violating the parking rules in the community. So because the towing company is always going to want you to designate a point of contact that has the authority to call them up and say, hey, tow this car. You want that decision and that delegation of authority to be documented in your board meeting minutes. The other thing that I'll say is that, as with everything, board decisions and actions have to be reasonable. And so when you're wondering whether delegating a particular piece of the board's authority is something you're allowed to do or makes sense, you have to also consider whether delegating that particular authority is a reasonable choice to make. And sometimes you might not know. And then what I would say is consult with your association attorney, because one of the things one of the reasons it makes sense often to consult with your association attorney on certain questions is that when your attorney gives you legal advice about what's reasonable, what is consistent with the statutes and with your governing documents, there's also some shifting of liability once you go forward with that decision. If your attorney has said it's a good idea or it's something you can do under the law, you have created some sort of legal cover for the board in making that decision by relying on competent legal advice telling you that that's a reasonable thing for you to do. So I think that covers the question. Jennifer, if you had anything to add, please do.
I think you covered it.
Okay.
So our next question is, when an older community is adopting Ukiah, the original declarant is no longer involved and maybe no longer exists. If amending or redoing our declarations, does the original declarant remain the declarant? So for someone who isn't aware, the declarant is the original developer of the community. The declarant will always be the declarant. There's only one entity that created the community, and that's the declarant. So they will always be declarant. But once the declarant has sold all of their interests in the community, they have no authority or power. They always remain the entity that created the community, but any language regarding the declarant is obsolete. So if you are looking at having an attorney review and redo your documents, any language regarding declarant rights or declarant power, as long as the declarant has sold all of the interests, can be removed. It's obsolete. It doesn't need to be there anymore. But there does need to be a reference to the declarant in the recitals, because that's who developed the community in the first place. Valerie, did you have anything to add to that?
No, I think you covered it. So I'll jump to our next question. Loan accounting for our HOA is challenging because owners had the option of the loan or lump sum, and each owner's special assessment is different. So loan payment amounts vary. Is this a common situation? Our association management company does not seem to track the loan payments. So is the board supposed to do that? So I'll start with the first question, which is this a common situation? And the answer to that question is yes. It is a very common situation that in a special assessment situation with an HOA loan, owners might pay a lump sum to avoid ongoing payments over time. The owners who need to participate in the loan would then pay their portion of the special assessment, which is dictated by the percentage allocations set forth in the declaration. And that's why they're all different amounts, right? It is unusual, however, that a management company would be unable to track the loan payments. So part of me, when I was reading this question, was wondering if this is just maybe a disconnect in communication between the management company and the person asking the question, because I deal with a lot of collection accounts. I mean, I've been doing collections for the last 16 years. That's part of my practice for my community association clients. And I've never received an account from a management company where they didn't have a very clear accounting of what charges are assessed against the account and what payments are being made on that account. Sometimes the special assessment installments will be added to the normal unit owner ledger, and they'll be all on one. Some management companies will track the special assessment separately on a different ledger for the same unit owner. But I've never had a management company be unable to tell me this was the amount of the special assessment for this unit. These are the charges each month. These are the payments each month. So that would be unusual to me. I think that if you have a management or bookkeeping service, they should be tracking all the payments and the assessments or the charges, and they should be able to produce an accounting ledger showing the payments made by that owner against the balance of the special assessment for that unit. The board should be monitoring those payments as well. So as your management company is providing you with financials each month, including your delinquency report, that is something that you should be paying attention to. Your treasurer in particular should be looking closely at all of the financial reports that are provided to the board by management. You should all also be familiar with the timeline dictated by your collection policy for taking action on delinquent accounts, so that you can be working closely with your management company about ensuring delinquencies are referred to counsel at the appropriate time, or that you can try to contact and work with the owner if they're having a hardship or are otherwise struggling to make payments. So there is definitely board responsibility, even when you have a management company, to oversee this stuff, to make sure that you're asking questions, that you're understanding the way that payments and charges are being tracked. But it would seem really unusual to me if your management company doesn't actually track the loan payments and the special assessment payments. And so that might just be a disconnect in communication. And I think that's all I'm probably able to say on this topic. Jennifer, did you have anything you wanted to add?
I think you covered it.
Okay.
So our next question is, are homeowners' names protected if another homeowner wants to review how units voted for a special assessment? Maybe. The reason why we say that is that all statutes, the Old Act, New Act, HOA Act, and UKIWA all have provisions regarding records. The UKIWA provision is 6490-495. Ballots are records of the association and must be kept for a year after the vote was taken. But individual unit files are not disclosable, and that particular provision under UKIWA is 6490-495 sub 3 sub H. Whether the vote of an owner is part of their individual file, we don't know. No court has taken up that particular question. So UKIWA was amended last year to provide for secret ballots, but that particular provision, 6490-45, excuse me, it's where did it go? 6490-455 sub 9. Specific votes are conducted by secret ballot, and these are enumerated or listed in the statute. So elections of board members, removal of board members or officers, amendments to the declaration or governing documents. Thanks, Valerie. Or unit owner approval of an amendment to the declaration for reallocation of a common element as a limited common element. Those are the only provisions right now under Ukiah that require secret ballot. So we don't know how a court would rule in this because as a country, we have a very specific history of wanting secret ballots for voting. Some courts in other states have held that owners don't have the right to see how their neighbors voted on any matter. That being said, there should be some way for an owner to audit or verify the outcome of any vote. It may mean using a third party to verify the voting results, but we just don't know how a court is going to rule on this particular issue. So you could provide the ballots, but somehow redact specific owner information so that owners can view the voting records and compile them as they wish, compile them and double check the count. We just don't know how this is going to play out. Valerie, did you have anything to add?
Yeah, my only other thought is that, and this came up when we were doing our prep with Ken, because there is a specific subset of topics that are subject to secret balloting under the statute. I think there is a strong argument that could be made that anything that's not on that list is not entitled to a secret ballot. So I think that's an argument that I would anticipate somebody making if they wanted to see every ballot and who voted how on a special assessment. On the other hand, I think that if you provided redacted copies of the ballots, in other words, you produce a PDF with every single ballot that was received on that special assessment vote, and you redacted the unit owners' names and unit numbers so that it was easy to disclose all of the actual votes without disclosing the names and unit numbers of the people that voted. I think the chances that somebody would sue and be successful when you make such an effort to disclose as much as you know you can without disclosing specific unit owner information, that seems to me like a really reasonable way to answer the concerns that might be brought up when trying to verify how votes went on a special assessment without knowing, as Jennifer said, exactly how a court would rule on this stuff, because all of these statutory provisions are relatively new. So until there are cases that test them in court, we are doing our very best to give you educated guesses on how a court would view different scenarios, basically. Okay, next question. When an owner decides to sell and finally addresses a safety concern in their unit, is the unit owner or the board responsible for ensuring that it is done to code? The board is aware of the whole situation and it has been discussed in meetings and emails, but there has been no oversight, only a contractor. So the short answer to this question is that it depends on what the issue was and what component was repaired. And the answer is not going to be the same for all fact patterns. And there's just too much that we don't know to answer this question. But also, even if you told us all the too much that we don't know, we wouldn't be able to answer the question because I'd be giving legal advice, right? So I'm going to try to give some general thoughts about this subject, but you probably need to ask this question to your attorney in order to determine what, if anything, your board needs to do about this specific scenario in your community. If you know that there's a safety concern, and I'm going to say that this is true well before somebody decides to sell their unit and address such a concern, most governing documents do set requirements for unit owner maintenance within their unit. And if the owner is not performing required maintenance or repairs, there is usually authority in the declaration that allows the board to go in and fix something after giving the unit owner notice and they haven't done it. I will offer this almost always requires a court order. So just because your documents say you have the right to go in and do the thing the owner hasn't done, doesn't mean that you can break into their unit when they're telling you, no, don't come in. That's a situation where you want to file a lawsuit and get a court order authorizing you to enter the unit even without the owner's permission. So what I'll say is, generally, if you know that there's a safety issue like this, don't wait until the owner decides to deal with it, or don't wait until they sell their unit. Be proactive, communicate with the owner, notify them of their obligation, in your opinion, to repair whatever the issue is. Try to work with them to get it handled in a proactive, timely manner. And consult with your association attorney, depending on what the issue is. If it rises to the level of something that's urgent enough, you might want to consider the option of going to court and getting that court order so you can go in and address the issue as an association and then assess the cost to the unit. Generally, if the repair touches a structure or common system that is the association's responsibility, so we're talking, structural walls, plumbing, electrical, HVAC, that kind of thing, it is both possible that a permit might be required and also possible that the association is actually the one responsible for the maintenance and repair of that component. And even if the owner took it upon themselves to fix whatever it was, you want to be able to ensure that it was done correctly, that any permits that are required have been obtained, and that there is an inspection after the fact to make sure that the work is not going to create additional problems for the community. In that scenario, and in particular, if it's a component that the association is responsible for, the board is always the one that has the ultimate authority and can require that the work be done by licensed, bonded contractors that are chosen by the board, not by the unit owner. So again, this is what goes back to the fact that it depends on what's being repaired. I will also offer that one thing you should keep in mind when you know that there are either unauthorized modifications or safety concerns within a unit, and a unit owner is not addressing them and they put their unit on the market, the resale certificate is an opportunity for you to disclose any such issues that would inform a buyer about violations of the building code, violations of the governing documents, and any necessary work that would have to be done to bring the unit into compliance with either code or the governing documents. So this is a very long way of saying we cannot answer this question, because what you really are asking for, even though I'm sure you didn't mean to, is legal advice. You need to send this question to your attorney, and you're going to have to give them a whole lot more information, including what was the safety concern, how exactly was it repaired, so they can look at your governing documents, tell you who actually has the authority over this component that was repaired, and what steps you might need to take to make sure that it was all done correctly. Jennifer, did you have anything you wanted to add to that?
Just briefly, we have, excuse me, run into this situation several times where owners just remove a wall or do something to affect a common element in the association. And it works best to have your association attorney help you with that particular situation, because there are specific procedures for gaining access to units that aren't always followed, and it just causes problems. So this is a really specific situation. So please get legal advice to help you navigate this. So our next question is, can a board set quiet hours that are more restrictive than what is laid out in a city code? If specifics are needed, the board setting a rule not allowing any type of construction activity on a Sunday, even though it's allowed under city code. And as long as the rule is reasonable, and published to the owners before enforcement, probably yes. You would need to have some authority for rulemaking, either in statute. So that rulemaking authority is in 6434, 6438, and 6490. 6432, the 6434 provision does apply to old act condos as well. So a rule prohibiting construction on a Sunday likely would be enforceable for a stacked condominium development. If you're talking a single family HOA where each lot is like a quarter acre, it's probably not that as reasonable, because there's not as much noise transference or issues with a single family standalone home than there is with stacked units. So is the rule reasonable under your particular circumstances? It may or may not be enforceable, but really it depends on the particular circumstances. Valerie, did you have anything to add to that?
Nope, I think you covered it. Our next question is, when a homeowner has paid a fine for noise complaints, does this close the issue? Should the unit cause more issues in the short-term future? So I think the question essentially is, are fines or are violations kind of standalone once and done, and always separate? So I think the question of the violation is separate from the question of the fine. If somebody pays the fine, that closes the issue of the outstanding fine. But if there are more occurrences of the same type of violation, that might be, depending on the contents of your governing documents, a continuing or ongoing violation. So it depends on the language in your enforcement procedures, whether a new violation of the same type occurs within a short time frame, like say 6 months or less, that it might be able to be treated as a second or third violation of the same type. If you have one of those fine policies that allows for escalating fines after repetition of the same violation, that could qualify. I do think the time frame is really important. Even if your fine policy specifically provides for escalating fines for repeated or continued violations, it is one thing to say that this unit holds parties twice a month. That's a continuing or repeated violation and should be subject to the escalating fines. And it's another thing to issue a warning letter and then 10 months later say, well, that's a repeat or continued violation that should be subject to those increased fines over time. And I can't tell you that there is a black and white, always true time frame during which, if it's less than this many months, then you're safe. If it's more than this many months that you're not, then you're not safe to treat it as an ongoing or repeated violation. I think it really depends on the circumstances, on what the violation is, how frequently it's being repeated, how consistently you are complying with your fine procedures, your enforcement procedures. So all of that being said, a couple of things sort of that are more overarching when you're dealing with situations like this. Number one, if you don't have a fine schedule, a published schedule of fines, then you can't fine people under the statutes. So that is something that you need to get in place if you don't already have it in place. On the other hand, fines are not the only enforcement mechanism. So we always like to remind people that calling your owners up, your neighbors up, whoever it is that is, if it's a noise complaint, if it's they're leaving their trash cans out at the curb, whatever the thing is, having a conversation with them and asking them for voluntary compliance is always a great option. Fines obviously are one of your options, but if they don't work, you can also look to your governing documents for other options, including whether you might want to ask the owner to go to mediation to try to solve the issue that's being caused by the violation. Or depending on whether the problem rises to this level, litigation might also be an option. The problem with litigation is that it's expensive, it takes a long time, and it doesn't always resolve the dispute in a way that preserves the homeowner association relationship. And one of the things that we're always really mindful of whenever our clients ask us to step in and help with a dispute between the association and the homeowner, whether it is assessment related, whether it's enforcement related, whether it's two neighbors that are just feuding for whatever reason, we're always really mindful of the fact that you all are going to continue living in that community together long after our involvement in whatever the dispute is has passed. And we think it's really important for you all as managers, as board members, and as homeowners too, to remember the same thing, that there is a neighbor relationship that is worth preserving, because once the dispute's over, you guys are still living in the same place together. So I think that covers it. Jennifer, did you have anything you wanted to add?
No, I think you covered it.
Okay, so we're going to switch things up here. I'm going to do 2 questions in a row, and then Jennifer has one that she's going to cover for you after this. So I am paraphrasing what was submitted as like a 3-paragraph, really long question about meeting agendas. And the question poses that meeting agendas are supposed to include the motions that will be voted on at a meeting. And it says possibly even the exact wording of motions, including the motions, makes holding the open forum section at the start of the meeting more meaningful, since owners are advised of what the board will discuss. I also understand that boards are supposed to do all their business at open meetings. My question is, how do we prepare an agenda without having some discussion or email exchanges among board members about what will be on the agenda? Is this strictly up to the president, or am I missing something here? So I think a couple of things. The most important thing is that you are publishing notice of your open meetings to your owners a minimum of 14 days before the meeting occurs, and that you are publishing the agenda to the meetings to the owners at the same time. And the agenda does not necessarily have to include every single motion that you plan to vote on, because you might not even know what the motion is going to be. But the agenda should include the subject matters that you know are going to be on open for discussion. And the statutes do not prohibit board members from emailing each other ever about anything. The statutes prohibit board members using email discussions to avoid the open meeting requirements. In other words, you can't have long, substantive conversations that would otherwise take place in a board meeting via email. That does not mean that you can't, let's say you're the secretary on your board and you remember that you guys said you wanted to vote at the next meeting about the landscaping contract. Poor landscapers, man. We use them as an example every single time we need an example. But anyways, there's no rule, nothing in the statute says that you can't email the president or the manager, whoever it is that's putting the agenda together for the next meeting, to say, hey, don't forget to include the landscaping situation on the agenda for this month's meeting. There's nothing in the statutes that says you can't do that. What you can't do is, hey, we said we were going to talk about the landscaping thing next month at the meeting. Here's 7 paragraphs of my thoughts on this issue. What do you all think? And then have that whole discussion via email, so that you then do not have that discussion at the board meeting. That's where the line is, okay? So the other thing that you can do is the statutes specifically provide that when you establish an annual meeting schedule, meaning ahead of time, you decide that for the year 2025, our board meetings are going to be on the 3rd Thursday of every month at 6 o'clock in the clubhouse or at the library meeting room down the road. You can send a notice to your owners that says, for the year 2025, this is our board meeting schedule. This is the general agenda: old business, call to order, roll call, approval of last month's minutes, old business, new business, general topics, financial report, whatever. You can publish a general agenda, which would necessarily not allow you to include the content of specific motions, because you're not going to know that, 6 months, 11 months in advance of the board meeting. You're publishing that schedule for the full year in advance. But you can put a general agenda together so that your owners always have at least an expectation of generally how the board meeting is going to go. The other thing to keep in mind is that the new meeting statutes, and this one is also under revision right now, the WSCAI meeting section. And if the bill passes, which I think is highly likely, the meeting section of WSCAI will become applicable to everybody on January 1st of 2026 instead of waiting until 2028. The meetings provisions in WSCAI require you to make available to the owners all of the materials that the board is relying on in that board meeting. And so that might look like, everybody showing up for the in-person meeting and you having some copies of the packet that was given to the board, with a few exceptions if there's stuff that's supposed to be redacted or withheld. And owners can ask for a copy of that at the beginning of the meeting and you give it to them. If you're holding your board meetings via Zoom, it might look like you have a PDF of that packet and pop it into the chat at the beginning of the Zoom, so that owners can see the materials that the board is relying on as they discuss the issues that are going to be discussed at that particular meeting. That also supports the overarching legislative intent and goal here, which is keeping your owners informed, giving them as much information as possible. So the other sort of overarching thing that we will, you probably hear us say this word reasonable so many times it might make you want to vomit sometimes, right? Because there's no clear definition of what's always reasonable and what's not reasonable. But there's a reasonableness factor in making decisions about what to include on your agenda, how specific motions have to get, what should go in the board packet, for example, that you're disclosing to the owners at the beginning of the meeting, and what things can be withheld. As long as you are operating with the intent of disclosure, transparency, openness, you're not using emails to avoid discussion in an open board meeting, and you are complying with the legislative intent behind all of these changes to our statutes in the last few years, then I think that you're going to be fine. I think the question is maybe overthinking things a little bit, and believe me, I understand that tendency. It is deeply ingrained in my personality to be a little bit of an overthinker. I don't think you have to have the text of every exact motion in the agenda ahead of time. I think the important thing is that you are being as proactive as possible about informing your owners in advance, whenever possible, about the subject matters the board is going to be discussing at each meeting. And again, publishing that schedule a year in advance and using a general agenda does allow you to be a little bit more generic in those disclosures, especially because you are then also making the board packet available to the owners at the beginning of the meeting. I think that covers everything. Jennifer, did you have anything you wanted to add to that?
I don't think so.
Okay.
So our next question. Our association is about to transition to new management, according to 6490-495 sub 9. And I'm just going to paraphrase a little bit of it. The association's managing agent must deliver all of the association's original books and records to the association upon termination of its management relationship with the association or upon such other demand. Electronic records must be provided within 5 business days of termination or the board's demand. Written records must be provided within 10 days of termination or the board's demand. And then going on, in our experience, this seems to be an impossible standard. Did we just have a bad experience, or is that the norm? Either way, is there any enforcement mechanism when the standard is not met other than going to court? If we have not yet adopted Ukiah, would it still apply? So this particular provision of 6490-495 is not applicable to anyone who either has not adopted the statute or wasn't formed after July 1st of 2018. There's similar language in all the other statutes. It basically states an association's managing agent must deliver all of the association's original books and records to the association immediately upon termination of its management relationship or upon such other demand made by the board. So Ukiah was amended because immediately is unreasonable. But the only enforcement mechanism for this is the courts. There's no governing body to management companies that will smack them around and make them disclose records. Sometimes calls from the association's attorney or a written demand from the association's attorney to comply may gain you some traction, but it's a well-intended effort from the legislature to address a problem in the industry, but it has little to no effective enforcement capability. Even if you sue, it could take weeks or months for a court to rule on anything, and it may be difficult to establish any damages that you could recover from that management company. So we've dealt with this a lot in our practice. We have clients right now that are trying to get their original records back from a prior management company. Sometimes we're successful, sometimes we're not. It really depends on the management company and whether or not the board is willing and able to take the next step and actually file for an injunction to make the owner, make the prior management company release those records. So most management companies will comply, maybe not within that time frame, but they'll do their best to get the new management company or the board the records that have been requested. It's fairly, it doesn't happen often, but when it happens, it's usually a disaster. But most management companies want to comply. Some timeframes are less reasonable than others. but there really is no enforcement mechanism. Valerie, did you have anything to add to that?
Yeah, I have a couple of thoughts. One is, I think the ease with which a management company can turn over literally everything depends significantly on the length of time that a community was managed by that management company. So if you've only been with your management company for a couple of years, it should be a lot more straightforward for there to be a prompt turnover of documents and records and funds. If you've been with the same management company for 15 years, I think you're going to have to be a little bit more patient. And perhaps what you do is you work with your new management company and your association attorney to identify the records and things that are the most critical for your everyday operations and ask for those to be prioritized, and then have a little bit of understanding that if somebody has to go to, a storage unit to get bankers boxes full of files from 15 or 20 years ago, that part's going to take a little bit longer, right? So I think the actual facts of your management relationship and the history with that prior management company is relevant to how quickly things can be turned over. I think that's enough. I had another thought, but I don't think it's super helpful in this particular scenario. So I'm going to move us on to our next question. This is the question. Please provide guidance on the latest FinCEN press release stating that the Financial Crimes Enforcement Network is issuing an interim final rule that removes the requirement for U.S. companies and U.S. persons to report beneficial ownership information to FinCEN under the Corporate Transparency Act. We just held our annual meeting last week and elected new board members. Should I update our BOIR, removing the members who have gone off the board and adding the new ones? If it's not necessary anymore to update the BOIR, should I remove all information from our report as it is no longer an accurate filing? I'm going to start by saying that this question, actually, I'm probably going to start and end by saying you're asking for specific advice for your community, and we cannot give you advice in this forum. So if you want somebody to tell you what you should do, as the question indicates, you need to just copy and paste this question and send it to your attorney so they can give you specific advice for your community. As I mentioned earlier during the announcements, the requirement for U.S. companies to file the BOIR is currently suspended. I'm not going to say it's gone because it's still in the statute. It's just that there is this interim final rule that removes the requirement for U.S. companies and individuals to comply with it. But it could be reinstated under a different administration or even under this one. The law does still exist. It's just that Treasury is choosing not to enforce it for now. So that's as much as we can say in this context without giving legal advice. So like I said, you should copy and paste this question and send it to your association attorney so they can give you advice for your community. Jennifer, do you have anything to add?
No, I think you covered it. So our next question is, can homeowners request the history of a special assessment budget vote? And we've answered this question pretty thoroughly earlier in the presentation. So in a nutshell, the actual ballots are a record of the association and are disclosable. The identifying information for the unit owner, we don't believe is. There is specific language regarding what topics can be done by secret ballot, and voting on assessments or a special assessment is not one of them. We don't want to give out individual owners' votes, so it is probably enough if you released the ballots but redacted the unit owner name, and any identifying information to that particular unit. This has not been tested in the courts, so we don't know how a court would respond to that. Valerie, did you have anything to add?
Nope, that's it.
Okay, and we're at the last of our prepared questions. So if you have any questions, we'll probably have time, so feel free to put them in the chat. So the last question is, what are the liability issues surrounding events held by an HOA or condominium association? Can you host events as a board in common areas? Can you highlight neighboring businesses for happy hours or the arts? Are there ground rules that should be followed? So the board and association would have the same liability as an individual, sorry about that, holding an event on common areas or within the community. So check with your insurance agent about a special event policy, a liquor server policy. Whatever event that you're wanting to hold, check with your insurance agent to see what they would recommend. So that takes care of the insurance side. When it comes to promoting local businesses, there may be some issues. The association should not be recommending a business, but you can highlight or just tell everyone, hey, we're having happy hour. Everyone's invited at this location. And hold an event that way. So you might be able to inform owners of events happening at a business. There are a lot of specific details that we'd want to know before we gave specific advice to a client. A downtown high-rise condo may have different circumstances than a suburban HOA of single-family homes. So using my example of a happy hour, having just making everyone know that people are going to be at this particular business at this particular time is different than, hey, this individual business will give you a discount if you can show your ownership in our community. There are really a lot of moving parts here, but the association should not be recommending businesses to association members just because there could be some liability issues if that particular business has a problem or that particular owner has a problem with that business. Valerie, did you want to add anything to that?
No, I don't have anything to add, and I think we can jump into the few questions that came in via the chat. So the first one is, for a condo association, do tabs or licensing have to be current in order to be parked in the driveway of the unit owner? I'm going to just start with that one, and then Jennifer, you can add any thoughts that you have. No, unless your documents require it, but also there's some other moving parts here that would affect the answer to this question, which include whether the parking spots or the driveway are part of the unit, like a deeded part of the unit, or if it is a limited common element that's administered by the association. And it's a little interesting that it says it's a condo association, but you're parking in the driveway. So are these townhouse style condominiums, or is it one of those rare single family home communities that's actually legally structured as a condominium, which is also possible? So the answer to this question isn't going to always be the same. What I will offer is we do have clients that require that any vehicles parked within the community have to be in operable condition, licensed, and current tabs and all of that in order to remain parked in the community. But typically the authority to enforce that depends on the parking spots being a limited common element that the association has the authority to regulate the use of. Jennifer, did you have anything you wanted to add to that one?
Just briefly. So honestly, the answer depends on what's in your governing documents. As Valerie said, it also depends on whether the board has the authority to regulate use of that particular area. So if your governing documents state that the board has the authority to require all vehicles parked within the community to be in operable condition, you can make an argument that not being licensed with current tabs is a violation of that. However, we have run into associations who have tried to mandate that every vehicle within the association be licensed in Washington state, and you cannot do that. So answer is, it depends on what's in your governing documents. If you have a specific question on this, please contact your association attorney because there could be liability if you get something wrong.
Thanks, Jennifer. The next question that came into the chat was this: can an email vote be considered an official vote for the rental cap amendment if the owner is unable to fill out a PDF document and prefers not to spend money on postage for mailing? I mean, the short answer to this question is yes. As long as you can verify that the vote is coming from the unit owner, there's no reason that they can't send you an email that says, I vote in favor of the proposed rental amendment. The caveats that I have is that there are some fairly specific instructions about voting without a meeting. If you're proposing to do voting without a meeting for an amendment to the declaration. And in that case, you want to make sure that you review the governing statutes and the voting section to make sure that you're complying with all the correct steps. But the statutes actually specifically contemplate electronic voting, and I don't see why an email would be any different than a fillable PDF that somebody is typing their vote into. Jennifer, did you have anything to add on that one?
I don't think so.
Great.
I think you covered it pretty well.
Okay. All right, we have one more question from the chat, and it is this: are you saying homeowners should state their concerns before the business part of a board meeting, or can it be done at the end in the open forum? And I'm going to start with this one because I serve on the Legislative Action Committee, and the meeting section of WCAI is currently being revised to specifically handle this question. And that section of WCAI is likely to be made applicable to everyone on January 1st of 2026. And not only will that mean that every common interest community in Washington has to have open board meetings, which is not currently the case. Non-WCAI condominium associations are not required to have open board meetings unless their documents say that they have to. One of the changes to the statute that's being modified right now to the bill actually is that the homeowner forum, the part where the owners get to talk to the board about the business of the association, is moved to the front of the meeting as opposed to the back of the meeting. It's at the beginning of the meeting instead of at the end. And the reason for that, if you just think about this as a practical matter, is if the owner forum is at the end of the meeting when the board has already voted all the things, then what's the point of the owners being able to talk to you about the stuff that you've already made decisions about? So the owner forum, if you move it to the beginning of the meeting and the owners have been given the agenda ahead of time and the owners have been given the packet of information that the board is relying on to make its decisions and hold its discussions about various items on the agenda that day, that means that the owner forum at the beginning of the meeting, the owners have the opportunity to talk to the board about the votes that you're going to make in the later part of the meeting. And it is entirely possible that an owner might raise a concern or suggest something that could change how a board member or the entire board might think about or land on how to proceed with a given situation that you're facing. So I think that it makes a ton of sense to have the owner forum part of the meeting at the beginning so that you actually get to hear what your owners have to say and hear their questions before you have the discussion and make your motions and vote on those motions at the board meeting. That is not currently the way the statutes read. Currently, it is not required that the owner forum be at the beginning of the meeting, even for those communities that do have open board meeting requirements. And we are aware that most of our clients have that owner forum at the end of the board meeting rather than at the beginning. But I would encourage any community that's looking to start transitioning to the way that WCAI is going to make us all operate here soon enough to consider making this change sooner rather than later, because as a practical matter, it just makes a ton of sense to me. You want your owners to have a voice. That's the whole point of providing an owner forum, and giving them a voice before you make your decisions makes a lot of sense to me. Did you have anything to add to that one, Jennifer?
Just briefly, I would point out that under the amendments to Ukiah, as I understand it now, the owners forum is a set piece amount of time.
Correct.
So each individual owner would get, I think it's up to 90 seconds. Is that right?
Yeah.
You can always have more if there's fewer owners who want to speak, but the legislature isn't requiring you to spend an hour on the owner forum before you can get to board business. It's just they want to be able to have owners speak to the board about their concerns before the board votes on particular topics.
Well, that brings us to 10:59, and that's good because we are out of questions. So thank you all for joining us today, and we will look forward to seeing you here next week. Bye, everybody.
Bye.